Good afternoon, everyone. My name is Lluc Cerda. I'm with Samfiru Tumarkin. We are here live at the Employment Law Show. Nice to have you. We're talking today for the next half hour about your employment rights. I'm the senior associate for Samfiru Tumarkin at our Calgary office here, managing the office here in Alberta. So I'll be focusing mainly on developments in employment law in Alberta. But of course, I'm happy to discuss any questions you might have for employment law questions in Alberta, BC, or Ontario. So let's get started. The big news over the weekend was that the Premier Jason Kenney has basically put an end to most, if not all, COVID restrictions in Alberta. And I was actually on the news on Friday discussing some of the impact that might have for employees who have been laid off, placed on a leave of absence, or terminated due to COVID. So obviously, this kind of shows that employers were acting a bit prematurely by placing people on leave of absence. A lot of reports out there that the Omicron surge resulted in a lot of infections, including in the workplace, but that these workplaces might have been 90% or more vaccinated. And so a lot of the infections were coming from vaccinated employees, which goes to show that the effectiveness of banning employees who were not vaccinated, but who were otherwise willing to test, willing to wear masks, willing to comply with the orders in place at the time, was premature. The law is quite clear that misconduct has to be quite serious to warrant a termination for cause or a leave of absence without pay. And it's becoming more and more clear that employers did not have that correct justification to dismiss employees or let them off without any pay on a leave of absence. We have our first question of the day from Pam Clegg. Pam asks, hello, I'm on an unpaid leave because of vaccination policy. Can I or should I sue for severance? Well, absolutely. That's precisely the issue that we're having here, is that we have employees who are basically at home with no pay, and the employer is somehow continuing to state that these people are employees. Well, to be employed, you need to be provided with hours. To be employed, you need to be provided with pay. If you're left at home, but your employer just hasn't had the opportunities to terminate you yet, then that's basically a constructive dismissal. Constructive dismissal is when a fundamental change happens to your employment contract and you can treat that fundamental change as a termination. In situations like that, you essentially quit, but even though you quit, you can claim your severance. So definitely you want to contact us, Pam, and see how we can help you out to go after your severance. We have a follow-up question. I work for the Marriott hotels and I'm on unpaid leave for vaccination policy. And so far their policy has not changed. So yes, and there is currently in Alberta no government mandate, all right? So there was never a government mandate requiring employees to be vaccinated. Some might say that AHS has required vaccination, but that mandate came from AHS's CEO. There's no one in Parliament, there's no one in Cabinet that required any employee in Alberta to be vaccinated. So this is all coming from the employer deciding on their own what kind of policy they want to have in place. So in those situations, the employer suffers the consequence of what happens when an employee decides to go after their severance. So definitely you can continue to go after your severance entitlements and go after your employer and sue them in court if need be. We have another question from Marc D'Occasion, who asks, how long can I be placed on leave of absence before I consider myself fired? Realistically, you can consider yourself fired from the first day of your leave of absence. A leave of absence is basically your employer saying, well, I haven't terminated you, but I'm not going to pay you and I'm not going to provide you with any hours. All right. It looks a lot like a termination to me, and it'll look a lot like a termination to the courts. To be employed, you need to be paid. It's a two-way street. So if they stop paying you and you haven't agreed to that, then that's a termination. That's a constructive dismissal, and you can go after your severance. Severance, remember, can be up to 24 months, so 2 years of salary. In fact, we have a tool right on our website that allows you to calculate your severance entitlements. To figure that out, just simply go to pocketemployment.lawyer.ca. You have the website on screen there. It's completely confidential. There's no obligation. You can simply look to see what you might be entitled to and then decide at your own leisure what you want to do. But at least you have the information you need to know what kind of rights you have and what kind of entitlements you have. We have another question from Ayam Inabule. Hi, I was placed on unpaid leave for not getting vaccinated and will be terminated after 8 weeks if I'm still not vaccinated. I got another job afterwards. Can I seek severance and damages? So yes, you can seek severance and damages. Depending on how much you're earning in your new employment, that might impact how much severance you're entitled to. Remember that if you're not being paid, you're entitled to a certain guaranteed amount under the Employment Standards Code here in Alberta, and you're entitled to the difference from what you were earning before and what you're making now, definitely. Melanie Bazani asks, how about in Ontario? So I think Melanie is asking about whether there are government mandates in Ontario. There are very, very limited government mandates in Ontario. The only ones that actually require staff to be vaccinated are for staff that work in long-term care homes. What Ontario government has done has asked certain sectors of the economy to have vaccination policies, such as universities are required to have a vaccination policy, but it's not the government that requires universities to have their staff vaccinated. In fact, the government gives universities the choice of either having vaccinated staff or having staff that agree to regular testing. So some universities have decided not to provide the option for regular testing, but that's their own decision. It's not the government's decision. And in fact, my understanding is the government is going to repeal the vaccination requirement in universities shortly as part of the opening of Ontario. Pam Clegg asks, what about temporary layoff? So a temporary layoff can be a constructive dismissal as well. If you've never been laid off before and you don't have an employment contract that says that the employer has the right to lay you off, then in fact the employer does not have that right. If you get laid off and you are not okay with it, contact us. We will help you get your severance. Because again, if you're not being provided with pay, then that's a constructive dismissal. There's no ifs, ands, or buts about it. So definitely contact us. We'll determine whether there's ever been an implied right to lay you off. And if there wasn't, if you've been laid off, you can go after your severance from the first day of your layoff. Absolutely. KA asks, if AHS does not change their policy, being unionized, what are my options? So when you're unionized, the rules are quite different than when you're not unionized. Unionized employees have access to their unions and only access to the union. So when you hire an employment lawyer like myself, I have the opportunity to take your claim to court and have a judge decide whether you've been constructively dismissed, whether you've been terminated, how much your severance should be. I cannot represent a unionized employee. The only person that can represent, or only entity that can represent a unionized employee is the union. And the law requires that any grievance that is made through the union be arbitrated, not taken to court through litigation, but taken to an arbitrator through arbitration. So if you are on unpaid leave at AHS and you're unionized, you have got to contact your union as quickly as possible to have your union help you get back to work, be it through agreeing to regular testing or a grievance or whatever you need to do, but it has to be through the union. If you're feeling you're not getting well represented by your union, then there is always the opportunity to bring an application for a failure in the duty of fair representation. It's an application you bring to the Alberta Labor Board. And the Labor Board will decide if you're being treated fairly by your union, and if you're not, the Labor Board will order the union to represent you more fairly. So if you have any questions about that, contact the Labor Board and they can give you more details about that. Ashley Molyneux asks, would a medical leave of absence be considered as constructive dismissal due to mental illness from an unprofessional treatment from a manager, especially if my doctor does not want me to go back to work for the company? So, two things. If you are being uh, bullied or harassed at work, that is the constructive dismissal. Okay, you can treat the poisoned work environment as a constructive dismissal. Uh, the, you have additional proof that it was a poisoned work environment by the fact that you had to go on medical leave. All right. People can go on medical leave for any variety of reasons. For instance, you get cancer, it's completely unrelated to your job. You go on medical leave. You can't claim constructive dismissal because you yourself asked to go on medical leave. If you go on medical leave because of a poisoned work environment, it's not the medical leave that's a constructive dismissal because you asked for it through your doctor. It's the fact that you were working in a poisoned work environment, in which case you can go after your severance, absolutely. Mr. P asks, if you are given a leave without pay notice, can they call you back? Are you obligated to go back? Would this situation affect your severance? So theoretically, your employer can call you back to work from a leave of absence, and then it's up to you to decide if you want to go back or not. So if you don't want to go back, then basically you can continue to pursue your severance entitlements. A judge might find that you should have gone back so that you had income instead of suing for the income that you are suing for right now. So it's a tricky question. It's important that you contact a lawyer if you do get called back to work to see how long it's been that you've been off work, whether your employer has offered to pay you the back pay for the time you've been off work, and whether that you think that there's a viable relationship to go back to. You'll never be forced to go back to an environment where there's going to be humiliation, where there's going to be conflict, where it's just going to be impossible to go back. You won't be forced to go back to a position that's materially different than the position you had before. So a lot of things to consider. So definitely you want to give us a call, reach out, see with us whether you have to go back or whether you can go after your severance. You can reach out to us at any time. We're at employmentlawyers.ca. You have the website there on your screen. Go ahead and contact us at employmentlawyers.ca. We'll be happy to speak with you to let you know where you stand. Jordan Christie asks, in the event your hours are reduced or eliminated due to trade sanctions, are you entitled to severance or EI? Also, if you are a part-time employee and do not have the hours earnings requirement, are there any other financial supports other than provincial income assistance? Okay, so let's start with the first question. So, we've all seen what's been happening in the world with Ukraine and Russia. There's been some sanctions that have been imposed. These will undoubtedly affect the economies of the world. That said, if your hours are reduced and your employer is saying it's because sanctions require us to reduce your hours, that can still be a constructive dismissal. Remember that any reduction in hours of over 10 to 15% is likely a constructive dismissal and it allows you to go after severance. The reason why is not that important. There's always going to be a reason why your hours are reduced. And generally it's because business is slow. Business can be slow for any number of reasons, including a war. And even if there's a war, doesn't mean that the employer can reduce your hours. All right. So that can still be a constructive dismissal. Absolutely. Regarding EI, if you don't have the the hours and earning requirements, it might be difficult to apply for EI. You should definitely contact EI to see if they have any other programs or services that they can direct you to. But that's the first place to go. If you have questions about EI, it's important you contact Service Canada directly. They'll be able to help you with any questions you have about their services. Next question is from Lucia Welsh. I'm in Hammer, Ontario, went on a medical leave in September last year, was off until February 18, 2022. I decided to take an early retirement, but do I still get severance pay because I felt I did not have a choice but to do that. And now I have found a minimum wage job, but I can't afford to live on what I was unionized as well. But my union has said they did not and would not represent me. So it's important to realize that retiring from your job is just like quitting, all right? And the general rule is when you quit, you do not get severance, all right? So if you're forced to retire, just as like if you're forced to quit, that can be a constructive dismissal, and that can entitle you to severance. That said, I'm giving you that information more generally because, as you mentioned, you're unionized. As I was saying earlier, we can't represent you if you're unionized. The only people who are allowed to represent you are your union. So you have to contact your union, see if they will represent you. They've told you they wouldn't, so you can contact the Ontario Labor Board and see how you can bring a duty of fair representation application against your union to see if they can force you, if the board can force your union to represent you on this. Jen Smith asks, if the mandates are lifting and you're on unpaid leave, are you entitled to your job back? So generally, an unpaid leave is supposed to be temporary. All right. So you have a decision to make. Do you want to go after your severance and claim constructive dismissal, or do you want to get your job back? In which case, you're kind of at the hands of your company, and you have to just wait until they call you back. It may be that they eventually call you back, but it's hard to predict when that'll be, because it wasn't the government forcing them to put you on leave of absence before. The government's not going to force them likely to take you back. All right. No one can really force an employer to take you back to work. That said, the situation is changing, so the employer's mind might change, but there's nothing legally to force them to take you back. That's never really in the cards. All you can really do is go after your severance. So you have a choice to make. Either you patiently wait for your employer to change their vaccine policy and call you back to work, or you decide to contact us and go after your severance. So those just joining. So my name is Lluc Cerda. I'm the senior associate here at Calgary office of Samfiru Tumarkin. I'm the managing associate of Samfiru Tumarkin. I'm talking to you about your employment rights today. I'm happy to talk about your employment rights, whether you're in BC, Alberta, or Ontario. I have a bit of a focus on Alberta today. We have 5 shows throughout the week, Monday to Friday, from our lawyers from across the country to answer your questions. So if anything is not answered today, feel free to log in again tomorrow or any other day this week. We'll be able to answer your questions. So I have a question from JC2004X. Young Labor Board in a union situation. Does it go to court? If so, which court? Provincial, Supreme? Okay. So beyond the Labor Board. Okay, so I understand. So basically, if you go to the Labor Board and the Labor Board makes a decision, either side can appeal that decision. That appeal will go to the court. All right, it'll go to the trial level court, as we can call it. So in Alberta, the trial level court is Court of Queen's Bench. After that is Court of Appeal. After that is Supreme Court. In Ontario, it's Superior Court of Justice. After that is Court of Appeal. After that is Supreme Court. In BC, it's a bit weird. It's Supreme Court of BC, then Court of Appeal, then Supreme Court of Canada. All that to say, you cannot appeal to the trial level court, but you can bring a judicial review, which is very similar, of a decision made by the Labor Board in each of these provinces. Yeah. Randolph Butternuts, good name, asks, what are my rights to severance if I'm a Hudson's Bay employee working at the Young Bloor location? So, Randolph, your severance rights are the same as any other employee in Ontario. All right, you're entitled to severance. It doesn't change just because Hudson's Bay is going through tough financial times or are closing a store. Your severance is going to be based on 4 main factors, which are your age, your length of service, the kind of job that you had, and the availability of similar work. That's what a court is going to look at. We've compressed that and made it into an easy-to-use severance pay calculator that you can access on our website. Simply go to pocketemploymentlawyer.ca. That's pocketemploymentlawyer.ca. Go on the website. It's going to ask you for these 4 main questions, and it's going to let you know what your severance entitlements can be. It's confidential. It's free of charge. There's no obligation. You want to know what your severance entitlements are, go to pocketemploymentlawyer.ca. Any of you can do this. It's free of charge, and figure out what your entitlements are. All right. So, yes, JC 2004 just corrected his typo, her typo. Thank you for that. Lucia Welsh uh, asked, I did work in a long term care home and was a PSW. So then, yes, there was a mandate in place requiring you to be vaccinated. So that is one of the, and this is in Ontario, that is one of the very few instances where the government was requiring staff to be vaccinated. So in that case, it's the government that's forcing your employer to force you to be vaccinated, in which case it makes it hard to blame the employer for forcing you to be vaccinated. Really, the blame lies with the government. And unfortunately, you can't go after severance from the government if the government is not your employer. The Dreamer asks, if an employer's place of business is closed for several weeks or months due to renovations, can that in itself be a termination and get severance? Absolutely, absolutely. So if your employer says, well, listen, I have cases of this precise thing. I have employees came to see me, well, we were terminated because our employer wants to renovate the location for 2 years. Doesn't change a thing. You were still terminated. You're entitled to severance. The employer might say, well, I'm going to lay you off for 2 years. Firstly, that's illegal. A layoff can't be that long, even if you were okay with the layoff. If you're not okay, you can go after your severance from the first day of your layoff. No one is required to stay on standby, waiting for their employer to renovate their employment location without any pay or compensation. You can go after your severance right away and we can help you. So contact us. You can reach out to us directly at any time on our website. The website address is employmentlawyer.ca. That's employmentlawyer.ca. We're okay. Now, JC 2004 asks, you mentioned that you can't represent us against a union. Have you or your firm ever represented a union or an employer against a union? So we have all sorts of clients. Yes, at times we have represented uh, people involved in unionized settings. Absolutely. But the vast majority of our work is representing non-unionized employees in their negotiations with employers over severance. So yes, we have represented people in the unionized context, or more often the unions or the employers in those contexts. Yes, we have. How accurate? Pen Clegg asks, how accurate is the pocket calculator? So the pocket calculator is based on thousands of cases decided by the courts on what an employee's severance entitlements are. All right. So it's very accurate in describing what kind of entitlements you have if you go to court within the range that's provided. All right. So obviously, the ultimate decision is made by the judge if you go to court on how much severance you're going to be. So it's not like there's a chart somewhere in a law book somewhere saying Pam Clegg is entitled to so much severance. There it is in the chart. Basically, a judge is going to look at those four main factors that we've incorporated into the pocket employment lawyer, which are your age, your length of service, the seniority of your position, and the availability of similar work. We've compiled those thousands of cases and come up with what the court will likely say, and it's usually a range. All right. So that's basically based on what's been decided in the past. So in my opinion, it's very accurate. We have a question coming in from Facebook from Elaine. My employer has given me 2 weeks notice due to my vaccine status, but I thought my restrictions were being lifted. Can they do that? So there's two parts to that question. So can they terminate you? And if so, how much severance are you owed? So generally, an employer can terminate you for almost any reason, all right, so long as they provide you with severance, all right. There is no law that says that an employer has to continue to employ you until the day you retire. Just like there's no law that requires you to continue to work with the employer till the day you retire, all right. It's a free country. People can choose either to work with each other or not work with each other. What happens is if the employer decides that it no longer wants to work with you, it has to provide you with severance. So the question now becomes, is 2 weeks a fair amount of severance. 2 weeks will, in almost all cases, be not enough severance. All right. But the best way to find that out is to contact us, and we will let you know what your severance entitlements are. Alternatively, you can do that yourself. Visit our website, pocketemploymentlawyer.ca. You have the severance pay calculator. Put in your information. We'll tell you what your severance entitlements are. All right. We have a question from Nisdu. Hi, sir. Due to sickness, I went for treatment. I come back after 7 months, and company gave me a termination letter. And I showed them the authentic medical report, but they did not accept it. What is your suggestion? So, just in my previous question, in my previous answer, I said that in most cases, the employer can terminate you if they want to. There are some situations where the employer is not allowed to terminate you. All right. And one of those situations is they cannot terminate you for having taken a leave of absence. They cannot terminate you because you had an illness. They cannot terminate you because you have a disability. All right. So that's discrimination on the basis of disability, essentially. If you're ready to return from a leave of absence, the employer has to give you back your job, or if your job doesn't exist anymore, a comparable job. All right. So the first thing you got to do is get in touch with us. We need to know more about this medical disability and what the employer is saying and why they're saying they can't take you back. Because the employer has obligations to help you get back to work, look at what your restrictions are, and help you get back to work. So reach out to us. You may be entitled to severance. You may be entitled to even more than severance because of discrimination based on disability. Very important you reach out to us to find out what your severance entitlements might be at NISTU. Kay, thanking us for answering your questions. My pleasure, Kay, anytime. And like I said, we're here all week. If more questions get asked, feel free to reach out because we are coming low on time. So I'm going to answer 2 more questions, and then I might have to wrap it up. Lucia Welsh asks, so how is it that they can hire someone who isn't qualified for the job as long as they're vaccinated? So again, who decides who's qualified? That's up to the employer to decide who's vaccinated. And unfortunately, that's not something you should concern yourself really. You should concern yourself really with was the employer allowed to terminate you or place you on a leave for not being vaccinated? In our view, they aren't. So you have to decide whether you want to go after your severance. If you do, reach out to us. We'll be happy to help. Jennifer Livemore asks, I work for a Crown corporation and submitted the attestation and requested a religious exemption. But before I had the chance to submit the affidavit, I went on medical leave. The company policy indicated that for anyone on leave, the COVID policy does not apply. But my employer said that I did not comply with the policy because the group insurance company said they did not support the medical leave, which I have appealed. And the insurance company is still reviewing my appeal. I have all support documents from my doctor. Is my employer correct for putting me on LWOP, which I guess means leave without pay? They are contradicting their own policy and listening to the insurance company. My ROE should say code D, not code N, which is which I am also working with EI and my employer to get changed. Yes. So remember that the insurance company only decides whether you're entitled to short-term or long-term disability. All right. The insurance company is not the people who decide whether you have a disability. All right. That's the doctor that decides that. So when your employer decides to take the insurance company's word over your doctor's, they are just lining themselves up for a lot of trouble. So if your employer has any reason to doubt what your doctor is saying, then they should ask questions of your doctor directly, not go through the third-party insurer. So essentially, I think that you are absolutely in the right, Jennifer, that they're not complying with their policy. If you submitted your disability request to the employer, gave your employer a doctor's note saying that you need to be off, if your employer has any questions about that, your employer needs to contact your doctor, not your disability provider. So you're absolutely in the right on that one. So that's all the time that we have today, folks. I really appreciate you coming to visit and tuning in. My name is Lluc Cerda. I'm a senior associate at Samfiru Tumarkin at our Calgary office. I manage the office here. I'll be back shortly in 2 weeks to speak to you more, but you'll find more of us ready to take all your questions tomorrow at 1 p.m. Eastern. So log on, save your questions. We'll have someone to answer them for you then. Thanks for